One of Justice Scalia's best opinions begins with this declaration. It is, quote, "the proudest boast of our democracy that we have a government of law and not of men," end of quote. The phrase comes from the Massachusetts Constitution of 1780. This infant state constitution linked the government of laws and not of men directly to the separation of powers. Justice Scalia said the founders, quote, "viewed the principle of separation of powers as the absolutely central guarantee of a just government, because without a secure structure of separated powers, our Bill of Rights would be worthless," end quote. In plain words, it was a desire to preserve and protect liberty and self-government that guided the framers as they designed our Constitution. As the founding charter they designed is a remarkable document, as we know. The Bill of Rights, of course, preserved liberty by restricting what the government may do. But the single most important feature of our Constitution isn't any particular enumerated right or even the entire Bill of Rights taken together. The most important feature of our Constitution is the design of the document itself. That design divides the limited power of government vertically between state and federal governments, and it distributes power horizontally between co-equal branches. It is this very delicate balance of power entrusted to competing factions that ensures that liberty for the people will endure. It's the Constitution's design that protects against the mischief that results from the concentration of political power. The founders understood this fundamental principle, and Justice Scalia understood it better than anyone. He was fond of telling law students, quote, "every tin-horn dictator in the world today, every president for life has a Bill of Rights, but the real key to the distinctiveness of America is the structure of our government." Our constitutional republic is also designed around the notion that the people, acting through their representatives, retain ultimate authority to govern. It was the people, through their representatives, who ratified the Constitution that establishes our system of government. Under that system, except where the Constitution has already answered the question, decisions are made by elected representatives. Elected, yes, but also accountable to the voters. But to endure, our system of self-government requires judges to apply the text of our laws as the people's representatives enacted them. So our judges, by design, play a crucial but limited role. They decide cases or controversies. But in resolving those cases, they may look only to the laws the people wrote. Judges are not free to rewrite statutes to get results they believe are more just. Judges are not free to reorder regulations to make them more fair. For sure, judges aren't free to update the Constitution. That's not their job. That power is retained by the people, acting through their elected representatives. And when our judges don't respect this limited power, when they substitute their own policy preferences for those in the legislative branch, they take from the American people the right to govern themselves. As that happens, inch by inch and step by step, representative government is undermined. The carefully constructed balance of power is upset, and individual liberty is lost. These aren't stale concepts. If anything, the enormous size, the enormous power, and the enormous complexity of the modern state renders them more relevant than ever before. In recent months, I've heard that now more than ever, we need a justice who is independent and who respects the separation of powers. Some of my colleagues seem to have rediscovered an appreciation for the need to confine each branch of government to its constitutional sphere. I don't question the sincerity of those concerns. Some of us have been alarmed by executive overreach and the threat it poses to separation of powers. Whether it was the executive branch unilaterally rewriting federal law, as the Obama administration did dozens of times, or the executive's repeated failure to enforce and defend the laws passed by Congress over the last 8 years, we've witnessed repeated abuses by one branch at the expense of the other two. Just ask the Supreme Court, which unanimously rejected arguments of the Obama administration made in more than 40 cases. The policies that drove those abuses were, of course, problematic, but policies can be changed and must be changed. To this senator, what's far more distressing about each executive overreach and each failure to defend the law is the damage that it does to the constitutional order. The damage those abuses inflict is far more difficult to undo than the policies that animated them. For, as John Adams observed, quote, liberty once lost is lost forever, end quote. So the separation of powers is just as critical today as it was during the administration, the last administration. And the preservation of our constitutional order, including the separation of powers, is just as crucial to our liberty today as it was when our founding charter was first adopted. No matter your politics, for all of these reasons, you should be concerned about the preservation of our constitutional order and, most importantly, the separation of powers. And if you're concerned about these things, as you should be, I want you to meet Judge Neil Gorsuch. Fortunately for every American, we have before us today a nominee whose body of professional work is defined by an unfailing commitment to these principles. His grasp on the separation of powers, including judicial independence, enlivens his body of work. As he explains, quote, to the founders, the legislative and judicial powers were distinct by nature, and their separation was among the most important liberty-protecting devices of the constitutional design, end of quote. About the executive, he writes that through, quote, the hard-won experiences under a tyrannical king, the founders found proof of the wisdom of government, of separated powers, end of quote. The judge's job, our nominee says, is to deliver on the promise that quote, all litigants, rich or poor, mighty or weak, will receive equal protection under the law and due process for their grievances, end of quote. The nominee before us understands that any judge worth the salt will, quote, regularly issue judgments with which they disagree as a matter of policy, all because they think that's what the law fairly demands, end of quote. Fundamentally, that is the difference between a legislator and a judge. All of us should keep this in mind during the course of this hearing. Judge, I'm afraid over the next couple of days, you'll get some questions that will cause you just to scratch your head. Truth be told, it should puzzle anyone who ever takes a civics class. We'll hear that when you rule for one party and against another in a case, it means you must be for the winner and against the loser. Senators will cite some opinions of yours, and then we'll hear that you're for the big guy and against the little guy. You will scratch your head when you hear this, because it's as if you judges write the laws instead of us senators. But if Congress passes a bad law as a judge, you're not allowed to just pretend that we pass a good law. The oath you take demands that you follow the law, even if you dislike the result. So if you hear that you're for some business or against some plaintiff, don't worry. We've heard all of that stuff before. It's an old claim from an even older playbook. You and I and the American people know whose responsibility it is to correct a law that produces a result that you dislike. It's the men and women sitting here with me. Good judges understand this. They know it isn't their job to fix the law. In a democracy, that right belongs to the people. It's for this reason that Justice Scalia said this, quote, "If you're going to be a good and faithful judge, you have to resign yourself to the fact that you're not always going to like the conclusion you reach. If you like them all the time, you're probably doing something wrong," end of quote. Judge, I look forward to hearing more about your exceptional record, and I look forward to the conversation we'll all have about the meaning of our Constitution and the job of a Supreme Court justice in our constitutional scheme.